On Wednesday, August 15, 2018, Crystal Mangum appeared in a Durham County Superior Courtroom to represent herself in a motions hearing related to her civil lawsuit of malicious prosecution filed against Durham Police Officer Marianne Bond and the Durham District Attorney's Office. Her complaint had to do with the 2-count charge of larceny of chosen action that was handed up in a grand jury indictment on April 18, 2011, along with murder in the death of Mangum's boyfriend, Reginald Day. Unbeknownst to most everyone, Mangum was greatly disadvantaged from the beginning, as all of the papers, notes, and documents she carried to assist with the presentation of her case in court were confiscated by the guards at the Goldsboro Women's Prison from whence she was being transferred. Without having references to case law, statutes, notes, and an outline, Mangum was forced to plead her case from memory. Although Mangum's friend Sidney Harr had made arrangements with the court for her to wear civilian clothes which he had purchased for her, she had to be insistent and persistent in order to get the guards at the receiving detention facility in Durham to permit her to get access and don the outfit. Mangum presented her case for malicious prosecution in the larceny charge by explaining how all 4 elements of the civil complaint had been met. 1. Lack of probable cause of the charge. 2. Maliciousness of the charge. 3. Institution or initiation of the charge by the defendants. And 4. The charge ending in a favorable outcome at the initial trial for Ms. Mangum.
The defendants are arguing on technicalities, and I'm arguing on the merits of the case, which are that the 4 elements for malicious prosecution are met, which are lack of probable cause, the defendant initiated the charge, there was malice involved, proven by the lack of probable cause, and the outcome was favorable to myself, the plaintiff.
Mangum requested to have a witness take the stand to testify. The judge asked the defendants if they had any objection, to which they responded that it depended upon who the witness was. When Mangum replied Sidney B. Harr, both defense attorneys objected fervently, citing a February 2013 permanent injunction against him, as well as a gatekeeper ruling in an unrelated federal court matter. The judge sustained the objection. Harr would not be testifying. Mangum then moved the court to gain access to an 18-page document from Dr. Clay Nichols' personal file that the trial court had deemed relevant to her case, but to which it denied her visual access. This motion was not to be ruled upon by the judge. Mangum also requested that she be released on her own recognizance, and it was also denied by the judge. Defendant Marianne Bond, a police officer of the Durham Police Department, was represented by Kimberly Raybird of the Durham City Attorney's Office, whereas defendant Durham District Attorney's Office was represented by Catherine Shields of the North Carolina Attorney General's Office. Both defense attorneys conceded the merits of Mangum's claim. They did not challenge or attack it in their defense. Instead, they built their defense on 2 technicalities. 1, the expiration of the 3-year statute of limitations, and 2, improper service of the summons and complaint. The defendants noted that the not guilty verdict was reached on November 22, 2013, and that the malicious prosecution complaint was filed on January 2, 2018. A period substantially lengthier than 3 years. On this ground, both attorneys requested that the malicious prosecution lawsuit be dismissed. Assistant Attorney General Shields argued that a specific statute under certain circumstances called for a summons and complaint against a state agency, for example, the Durham District Attorney's Office, to be served on the North Carolina Attorney General's Office. Because Mangum served the complaint directly on the state agency defendant itself and not the Attorney General's Office, Shields contended that the lawsuit should be dismissed. Mangum countered the defendant's assertions by maintaining that during the 3 years following the not guilty verdict, she had been under counsel of professional attorneys with whom she had relied upon to act in her best interest. None of her post-conviction attorneys mentioned or brought forth the possible malicious prosecution claim during this timely period. Disheartened by the feeble direct appeal led Mangum to discharge her appellate defense attorney. After Mangum was abandoned by the North Carolina Prisoner Legal Services litigation director in a letter dated January 17, 2017, her non-lawyer friend Har, who had held a hands-off posture with Mangum's case following a February 2013 injunction, began to take steps to provide legal assistance, as she otherwise had none, and was imprisoned without resources to fight for justice herself. Again, the malicious prosecution complaint was suggested to Crystal Mangum by Har, well after Mangum's prior legal counsels had allowed a timely filing to elapse. Before making her ruling, the judge did allow Mangum to introduce into evidence a syllabus that Har had prepared concerning the malicious prosecution and evidence of Mangum's innocence in Day's death and proof of criminality by state witnesses in procuring a guilty verdict. Judge Carolyn J. Thompson, a recent appointee of Governor Roy Cooper, was scheduled in place of Judge Jim Hardin, who was originally set to preside over the hearing. This was a concern because although the judge was African American, Har felt that she would be beholden to Cooper, a staunch adversary of Nifong and Mangum, stemming from the 2006 Duke Lacrosse case. For more than 6 years, Har had tried to meet with Mr. Cooper in order to present evidence of Mangum's innocence and proof of criminality by state witnesses responsible for Mangum's wrongful conviction. But the Attorney General turned governor consistently ignored him. It was as though Har, a Tar Heelian, did not even exist. Though the judge switch smacked of judge shopping on the part of the defendants, Har felt confident that the merits of the case would nonetheless result in a favorable summary judgment, or at least an advancement of the case to a jury trial in Superior Court. Har miscalculated as the judge eschewed the merits of the case, which were not a point of contention, and instead ruled against Miss Mangum based on trivial technicalities of untimeliness of filing and improper service. All motions of the defendants received a blanket approval, while motions of Mangum that were addressed by the judge were given a blanket denial.
In response to motions filed herein, the defendants filed motions to dismiss. The first ground being insufficient service of process by personal jurisdiction resulting therefrom, and the issue of statute of limitations, and also the pleadings are barred because the improper defendants were listed and served. The court respectfully grants the motions to dismiss your complaint herein for untimely filing. There's been no showing of fraud and misrepresentation as the exceptions which you argued before the court. and I will count the motion to dismiss on hereby allowed with prejudice.
Had Judge Harden adjudicated the case, the outcomes would have likely been fair, with Mangum probably being released on her own recognizance. The Roy Cooper connections to the Duke Lacrosse case and his appointee, Judge Carolyn J. Thompson, formed a formidable bond that even Lady Justice could not break. Mangum did not receive a fair hearing or a just ruling. Retaliation against the Me Too movement victim for breaking the silence in the Duke Lacrosse case a dozen years earlier was still in force.